therefore call on the chairperson of the committee to present the committee's report.
Thank you, Right Honourable Speaker. I second the motion.
I stated all over that at second reading, you don't second the motion. That is why I did not call on you to second the motion, but to present the committee's report.
Very well, Mr. Speaker. I would like to present the report on the committee on the Select Committee on Security and Intelligence on the Security and Intelligence Agencies Bill 2025. And to just mention a few highlights regarding the committee's deliberation on the report. Mr. Speaker, the report was presented to the committee and referred from the Speaker, and it was meant to be a joint committee sitting between the leadership of Defense and Interior Committee and the Committee on Security and Intelligence. Mr. Speaker, following the referral, the bill was gazetted, and the committee received several memos from certain security and state agencies, as well as members of the public and some civil society organizations. Mr. Speaker, in considering the bill at the committee, a few issues were highlighted that I shall actually make reference to for the sake of brevity. A few observations that the committee made was on the receipt of the bill, the fact that unfortunately at the time the bill did not actually speak the explanatory memorandum did not speak directly to the mischief that the bill sought to cure, and following which the Minister with oversight of the National Security Act, who is currently the Minister for Interior, actually came before the committee to clarify the reasons for which this bill was actually presented and some of the policy underpinnings of same, some of which the Minister has elucidated right here at plenary. Mr. Speaker, it was quite significant that the committee realized that there wasn't much said with regards to parliamentary oversight. And given the nexus between secrecy and accountability, the committee saw fit to include a section on parliamentary oversight, codified and well delineated, to make sure that that level of accountability that must come to bear with regards to our intelligence agencies is in the bill, to prevent the evasive nature that can sometimes be prevalent in that particular sector. Mr. Speaker, the committee also noted that there were certain additions that were sought to be made, which would have been in contravention with Article 83 of the Constitution. There were recommendations to actually compel the President in one of the clauses with regards to the membership of the National Security Council, which the committee actually felt strongly would actually limit the President's discretion with regards to selection of membership of the National Security Council. So the committee was of the opinion that the clause that pretty much locked the President in place with regards to a decision on the membership of 3 extra persons be actually deleted from the bill. Mr. Speaker, there was also a provision made for the appointment of a Deputy National Security Coordinator in order to make the burden of responsibility a little bit less with regards to the operations of the National Security Coordinator. One of the observations that was made in terms of the committee's deliberations and memos that came in was with the supposed creation of a new agency under the coordinator. This was later clarified, and the committee had this removed so that it actually is seen as the office of the coordinator, as opposed to a new agency that was to be created to allow for the maintenance of the architecture in a form that actually aligns with the Constitution. Mr. Speaker, with regard to the issuance of warrants, another issue that was flagged by the committee was the desire for the agencies to have the mandate to issue warrants, which the committee felt could result in an abuse of power, and therefore the issuance of warrant ought to be by a justice of the Supreme Court of Justice to prevent the abuse or possible abuse of citizens' rights by agencies who could issue these warrants on their own. With regards to the issues on human rights and data protection, the committee also felt strongly that there ought to be significant amount of safeguards in place with regards to data protection within the agency and with regards to the access of material that had been received through intelligence collection in the process. Mr. Speaker, in conclusion, given the recommendations made by the committee in collaboration with consultants who assisted the committee, it was concluded that this bill, incorporating the proposed amendments and with an enhanced version of the explanatory memo, certainly are in favor of this House passing this bill into law. And therefore, Mr. Speaker, without much ado, I would like to recommend that this House adopt this bill and pass the Security and Intelligence Agencies Bill 2025 into law. Thank you, Mr. Speaker.
Yes, honourable members, motion moved, reports of the committee presented. Pursuant to Standing Order 127, a full debate shall arise on the principles of the deal on the basis of the explanatory memorandum and the report of the committee. The floor is now therefore open. I recognize Honorable Patrick Yaguama.
Thank you very much, Mr. Speaker, for the opportunity to contribute to this motion. Mr. Speaker, it's welcoming to have a national security and intelligence bill being debated this afternoon. Mr. Speaker, I've gone through the report and I would like to draw your attention to paragraph 6.7, which deals with clauses 39 to 31. And before I go there, I would like to make reference to Article 18.2 of the Constitution. Mr. Speaker, Article 18.2 of the Constitution reads, with your permission, that no person shall be subjected to interference with the privacy of his home, property, correspondence, or communication, except in accordance with law, and as may be necessary in a free and democratic society for public safety or the economic well-being of the country, for the protection of health or morals, for prevention of disorder or crime, or for the protection of the rights of freedoms of others. Mr. Speaker, clauses 39 to 31 of this report deals with the powers that are going to be given to a superior court justice. From a report of the National Security Coordinator or any of his deputies to target persons and locations with specific rules for warrants authorizing interception of communications. Mr. Speaker, that's on paragraph 6.7 under the signature of the said judicial officer. Warrants authorizing specific persons to carry out powers such as intercepting communications or obtaining information and documents as stated. Mr. Speaker, this power or powers that are being given to the National Security Coordinator or any officer designated by the President under his hand must be exercised carefully under the Constitution, Mr. Speaker, because very often when persons are given such powers, they overreact, they breach people's privacy and fundamental human rights because of such orders. And we want the courts to be very firm and undertake the right steps when granting such orders. Mr. Speaker, it is also welcoming that the President is willing to cede his powers by appointing a national security minister. Mr. Speaker, most countries in the West African sub-region and in Africa have a designated minister for national security. And I know for a fact that the Interior Minister is acting as the minister responsible for national security. It will be very important for him to be given, for the President to appoint a minister for national security to assist with the hard work that he's undertaking for the country. We all know that we don't have a minister for defense as we speak, and we think it's a welcoming bill. Interfering with persons' privacy, intercepting their calls, searching their homes must be in accordance with the Constitution of the Republic of Ghana. And we'll be checking the activities of the National Security Coordinator and his operatives in the exercise of these functions. Mr. Speaker.
So you are speaking with specific reference to 29 to 31.
Yes, clauses 29 to 31, which deals with interception of communications under the hand of a judicial officer. It's on pages 4 and 5 of the report, Mr. Speaker.
I'm looking at the substantive bill, which make reference to application to the judge.
Yes. We are debating the report, Mr. Speaker.
Yeah, the principle and then the this thing.
So I can look at.
So I'm just drawing your attention to the fact that this is subject to an application made.
I'm saying that that person who is given that power must exercise those powers within the tenets of the law and the Constitution. That's all I'm saying.
Yes, but once a judge is the one going to grant the application,
I don't know
or
if you want to
refuse the
participate in
application.
the debate.
No, I'm not participating in the debate. But we want the factual situation to be out there.
So, Mr. Speaker, it's also welcoming that the Minister for Interior, with oversight responsibility over national security, is pushing this bill. I know how passionate he has been, and he's also giving impetus to the regional security councils and the district security councils, because you go to a district, somebody will be working there, performing the duties of a district security coordinator. That person ought to be known and approved by the minister responsible for national security. The structure, the security architecture that is being proposed here is going to be backed by law. So whoever breaches any of the provisions in the law could be taken on by any of the offenders. So I thank you, Mr. Speaker, for the opportunity. But my interest was on the interference and interception of our communications. I thank you very much, Mr. Speaker.
Honourable members, yes, Honourable Ntim for you.
Thank you, Right Honourable Speaker. I rise to contribute to the report that has been laid and to state that at the outset, the committee raised serious objection to and concerns on the explanatory memorandum that accompanied the bill, and as a matter of fact, observed a far departure from the content of the bill relative to what the memo itself sought to do. Mr. Speaker, one of those very glaring discrepancy was a principle that the bill seeks to create the Office of the National Security Coordinator as an agency, as an intelligence agency, which we disagreed and thought that it was improper for the central role that the Office of the National Security Coordinator ought to play in coordinating decisions that are taken at the National Security Council it ought not to be an agency, which was agreed upon by the sponsors of the bill and amendment consequently made. On page 6 of the report, Mr. Speaker, I refer you to page 6 of the report. The committee observed that the explanatory memorandum does not clearly set out policy objectives and underlying principles of the bill, nor does it accurately identify defects or mischief in existing law that the bill seeks to cure as required under Article 1062 of the 1992 Constitution. We thought that sufficient justification was not given to the particular mischief that the new bill sought to cure, and failure to provide sufficient justification for the mischief went to suggest that there may not even be a need for a new bill to overhaul or to repeal the existing one, and that specific amendments in Act 1030 could have sufficed. But that decision elicited further position from the sponsors and provided further information and policy clarity, which persuaded the committee to accept. But in furtherance to that, the membership or composition of the regional security councils and the district security councils, as noted on page 8 of the report, was problematic, and we observed that it wasn't in consonance with the directive, the policy directive as enshrined in Article 83 of the Constitution, which provides the framework for the composition of the National Security Council, from which we draw the composition of the security councils at the regional and district level, i.e. the proposed inclusion of National Insurance Authority, National Identification Authority, the National Ambulance Service, Narcotics Control Commission, and members of Parliament. The proposed inclusion that the policy sought to include at the regional security councils and district security councils, we opposed and thought that was problematic and inappropriate, for which that needed to be looked at. And again, on parliamentary oversight, surprisingly, no provision was clearly indicated or no policy direction was given as to how parliamentary oversight of the intelligence function will be exercised, and for which the committee insisted an inclusion of a clause dedicated to providing mechanisms for parliamentary oversight of the intelligence sector. And that said, Mr. Speaker, the appointment of the minister that will be responsible for national security and by extension intelligence was a matter that needed serious clarity. Because from practice in this country, reference to Act 526 and Act 1030, two schools of thought have existed. One school of thought that actually sought to create the Ministry of National Security, and another school of thought where a minister responsible for national security was appointed without the necessary creation of a whole bureaucracy for that function. And in order that, in the passage of this bill, we would not come back in the shortest possible time for an amendment to be occasioned to that portion, we sought clarity and advice that we couch that provision in a way that will stand the test of time and will be able to serve those school of thoughts in the event that future presidents differ in principle. So that was agreed upon, such that in the current position agreed upon in this bill, the president would have the prerogative to appoint a minister, any minister, to be responsible for the function of intelligence and national security. Any minister may be appointed, and by interpretation, what that also means is that if any president so desires that he wants to create a whole bureaucracy for it, there would not be a need to come back to Parliament to amend that provision, and EI can be invoked for that to happen, to strengthen the resilience of this bill. That said, Mr. Speaker, on the appointment of the National Security Coordinator, we saw that no direction was given as to how the deputy national security coordinator should be appointed, for which we raise concerns because there's an incumbent deputy national security coordinator, and we needed to seek clarity that at the promulgation of this law, some people may not have to lose their jobs, and that was also factored in. But one of the key areas of contention was the constitutional basis for which that appointment will be taken. Whether the National Security Coordinator ought to be appointed under Article 195 or Article 70, considering the political nature over the years. We've all known that the roles of National Security Coordinator has always been conterminous with that of the president that appointed him. Even in times when you have had different presidents from the same party or government, we have never had a National Security Coordinator repeated. So we thought that then it should make sense for the incumbent to be appointed under Article 70. But that matter did not see consensus, and that in the subsequent life of this consideration, we will look at it and put it to bed. And so, Mr. Speaker, we recommend that the House takes this report, supports it, for us to pass a bill that will regulate the security sector governance of this country, particularly intelligence sector, and ensure that we have a creditable bill, a bill that will start in the sub-region and supports the function of intelligence in this country to enhance our security. I thank you.